right, so Andy and Kobe have talked about what you do while you're alive. I'm going to try to help you when things end. Let's see, I've never used one of these clickers, so bear with me. All right, since this photo here, I've added a child. I went to the American College of Trust and Estate Councils in D.C., finalizing a seminar I've been in for the last year. And one of the professors got up and was talking about jumping in straight to what you're talking about is no good if you don't know who the person is. So this is my family. I'm born and raised in Pigeon Forge. I've got 2 children. There's only one in that photo. That's from a few years ago. And you can see the most recent addition right there with my lovely wife. The highlight of my office is my dog is there every day. People don't come to see me. They come to see my dog. I did that just because I wanted her there, but I had no idea the impact that it has when somebody loses someone, having a dog there at the office. So it was an unintended benefit that's worked out really well. All right, as I said, born and raised in Pigeon Forge. Lisa went to school with my parents. Kobe is got a son that I graduated with, so there's a lot of friendly faces in here. Went to East Tennessee State University, was there for 4 years, came down to Knoxville, went to law school. Never thought that I would come back to Sevierville and practice law. Been there ever since. I was very fortunate to practice under Chuck Edwards, who was a retired judge, for the first 5 years of my practice. I would be remiss, the people who put this together for me as well as who keep my office running are these 3 folks. And again, they make me look much better and brighter than I actually am. I wanted to start also with, I'm going to go back here. My grandfather's a 91-year-old Baptist minister. So coming here and being able to speak to this is dear on my heart, as well as I've got an 8th generation farm that my boys now live on that I moved back to, once again, not thinking I would move back to the farm that I was raised on, which is about 3 miles from Wares Valley Ranch. It's just right over the ridge. So there's a lot of commonality in things that have interwoven or dovetailed with Wares Valley Ranch. My father's wife is a current Baptist preacher at First Red Bank Baptist Church. So once again, having the background of how I was raised and what the Wares Valley Ranch does is very close and dear. All right, let's talk death taxes. First and foremost, Tennessee abolished inheritance or death taxes in 2016. You can die with $100 million. It's not going to impact you at all. For married couples, starting January 1st of this year, you can die with $15 million, and I'm not worried about taxes or tax consequences whatsoever. As a married couple, you get a $30 million deduction. We've got 2 estates currently. One is a $100 million estate where they did no planning, and it is an absolute debacle. I've got one where they did planning 20 years ago and didn't update anything, and it's a $45 million estate. They should have went to Mr. Harper or perhaps Andy and gotten life insurance to pay the estate tax, because your estate tax above those exemption levels are 40%. So on that $100 million estate, we're looking at around a $30 million estate tax right now. All right. The question I get asked every day, right, and we're fortunate, we probably do 300 or 400 wills and trusts a year at the office, is do I do a will or do I do a trust? All right. Depending on your circumstances, I'm going to give you the answer that fits. I don't have a magic bullet. I wish I did. I'd be the richest lawyer in town. The truth is, trusts work when you have property in different states, or if you have high net worth and we're trying to avoid estate taxes. We're going to do irrevocable trusts. We're going to do charitable remainder trust, things that Kobe and Andy probably work with. However, for most people, we're just doing a simple will, right? And again, I'm happy to share this. If we don't hit what you're interested in, I'm happy to share any of this with you. You can contact my office. They're simple, they're cheap, they're easy to modify. I've had several lately that actually came in to see me on Wares Valley Ranch where they have family, and they're leaving a good portion to family and also a significant amount, depending on how much they have left when they're gone, to Wares Valley Ranch, right? Likewise with St. Jude's, we just gave $800,000 to St. Jude's tax-free, right? Because they came in, because they were able to do these things. As you'll notice here, right, as I was sitting here trying to modify this, every one of these is going to have a pros and a con. Every single one of them is going to say whether it's subject to court supervision or whether it's not subject to court supervision. Depending on the facts in the case, that can be good or bad, right? If I have people that are difficult to deal with, I need a court to intervene, right? If I've got a trust that doesn't allow that, then we're going to have complications, right? The problem with a will, right? It does go through probate. But I have court supervision so that when I have problems, I can deal directly with the court. I wanted to add, my grandfather was very disappointed in me when I became a lawyer and not a preacher. And I missed earlier, but those $15 million, they will get cost of living increases annually. So that will continue to go. The one common thing that comes into my office is that trust avoid probate. It's not true. Do y'all deal with that much where they think it avoids probate, they forget to fund it, right? You forget to put a piece of real estate, a bank account doesn't have a beneficiary, a brokerage account doesn't have a beneficiary, they leave something out of the trust, they've wasted thousands of dollars on a trust and still end up going through the probate process, right? So once you explain that, it really helps if you're going to have a trust to make sure that it stays funded, right? And that means whether it's an annual or every couple of years checking in and making sure that everything's in that trust so that we do avoid probate, sometimes that's worthwhile. But it is commonly overlooked. Whether you inherit a piece of property, many people that have major assets forget what all they have, right? So we've ran into that quite a bit as well. Trusts are overly expensive. If we become irrevocable, I'm sure you've got problems with irrevocable trust because your basis stays at what it was, right? And you don't get that stepped up basis on the increase or the appreciation in value, especially with a brokerage account, right? I want that stepped up basis. I don't want to miss out on that tax advantage. Let's talk real quick about probate. Everybody has a horror story about probate. Or does anybody? Let me ask it that way. Has anybody dealt with probate in a negative way? Interesting. Okay, well, my family went through probate on our family farm for 7 years. At the end of that probate process, again, didn't plan on being a lawyer at that time, the court forced the sale of our farm. It sold for $800,000 in 2007, and the attorneys got $500,000 of it. That's why probate gets a bad name, right? And I tell that story every single day, right? My great-grandmother didn't do any planning. People started fighting, and the court was forced to sell it due to what was happening. That's not standard, right? We usually do about 120 probates a year through my office. Out of those, 100 are smooth. The process lasts 4 to 6 months, depending on what's going on. State law says there's a 4-month creditor claim period where they can make a claim to the court and get paid. Outside of dealing with that, we usually wrap it up, pay St. Jude's, pay Wares Valley Ranch, whomever the beneficiaries are, or transfer the real estate, right? Like the like kind you were talking about with the University of Tennessee. All that happens pretty quick, subject to the exemption level with estate taxes. All right, testate means you die with a will. It's very easy. You follow the dictates of the will. Your executor has to do that. They typically don't have discretion. If you have a problem, you have court supervision to make sure that it goes to the proper people. If you die without a will, which happens very, very, very often. And by the way, wills aren't expensive. They're $400 or $500 for a simple will. They can get complex and would go up, but it's not that bad. You die without a will. I've got one right now with 200 heirs. They're not going to get much, right? Because we had to pay $11,000 for an heir search to get all of the folks, right? Once attorney fees are paid, once heir search fees are paid, there's not a lot left over typically. So again, even if you think your estate's simple, right, depending on what state law would do, and by the way, most people don't realize it doesn't roll over to your spouse. You die in Tennessee without a will and have children, your children will get, let's use the example, you have 2 kids. 2/3 goes to the kids, 1/3 goes to the surviving spouse. It's typically not what most people want, right? On top of that, although everybody says their kids will give it back, I'm here to tell you, that doesn't happen. All right, so real quick, types of probate. Most lawyers that don't deal with estate tax planning wouldn't know most of these. Full estate is what we just talked about. That's where we publicate in the Mountain Press or the local newspaper in circulation. 2 consecutive weeks. That begins our 4-month creditor claim period. We're usually able to liquidate brokerage accounts, transfer real estate, do everything that we need to do within that first 4 to 6 months, and then end the probate process. A simpler or more expedited probate is called a muniment of title. That's simply where I've got a piece of real estate, it's not planning on being sold, and we know who it goes to. We use the last will and testament, we record it in the Register of Deeds once we've met with the judge and got it approved, and then it becomes theirs. They can't do anything with that real estate for 1 year. After 1 year, they can sell it, but we do avoid going through the full probate process, and it's usually half the cost of an estate. The next is a small estate administration. All right, again, there's some requirements here, and it's changed recently. To do a small estate administration, you can have no real estate in the estate, meaning we're simply personal property or cash. You have to be below $50,000. I had one appointment this morning before I drove down here. They were about $30,000 away from being able to do a small estate administration, right? And so again, it pushed it over, and I told them they could roll the dice, but if they get looked at or audited, we're going to have problems, right? So again, they chose to do the full estate. That being said, as long as we're below $50,000, we can do that. We go to court one time, we vest the property, and then we pay creditors and move on. Last but not least is an affidavit of heirship. That's what happens when someone dies without a will. We want to avoid going through probate, and all heirs are in agreement. We can record an affidavit in the Register of Deeds office and vest the real estate. Before I change here, because I've got a few notes here, what I've been noticing is a lot of blended families, right? Against my grandfather's wishes as a Baptist minister and my father-in-law's, right? Most families, I would almost say 60% of the people coming into my office have blended families, meaning they both have children from prior marriages or relationships, and all that does is cause problems if we don't get it set on the forefront. All right. Again, everybody wants to typically avoid probate. That's why they come into my office, unless I can convince them to do a will and the benefits of that in court supervision in most cases. These are other options. The first option is a life estate deed, where we can transfer real estate to a remainder beneficiary and then keep it in the name of the person who just transferred it. It's there for life. Nobody can take it from them. Nobody can run them off. There are benefits to that, right? There's a 5-year look back for Medicaid. And so if we can keep the individual from going into a nursing home facility ran by TennCare, we can potentially keep that from being taken by the state later on if they run out of funds. However, once again, there's always consequences, right? There's going to be a pro and a con. I did a deed for a lady who had 2 boys. She was divorced. They were in their 40s. She deeded it to them, the remainder interest, her for life. One of them abruptly passed away in COVID. So his 50% went to his spouse who had been cheating on him. So now mom's living in a house knowing when she passes that the cheating spouse is going to get 50% and her son got the other 50%. Thankfully, she was a good daughter-in-law and a bad wife, and she deeded all the property back, so that situation worked out. But the point is, I didn't see that coming, nor did anybody else. So you have to be very careful when you do that. Joint accounts, typically I'm telling people I want beneficiaries or I want it held jointly, simply because I want all of that to pass outside of the probate process and go straight to the beneficiaries. I assume you would both fully agree with that. The only thing that I want going through probate is really your real estate and your personal property, and that's really to get that stepped up basis so we don't pay any capital gains when the new beneficiary receives it. POD, same way. If you don't hold it jointly, I want you to have beneficiaries on there, preferably contingent beneficiaries if your spouse or other family members are on it jointly. The only caveat to that is your IRAs can't have joint account holders on that, so you want specifically spouse because there's no tax consequences when it rolls over. Is that correct? However, if it's other beneficiaries, then they're going to have a 10-year drawdown period where they have to pay that tax. All right, and these are ancillary documents that usually go with the power or the last will and testament when they come in. Durable power of attorney, that helps with financial decision making. A healthcare power of attorney, when someone becomes incapacitated, that they can then make healthcare decisions, and a living will or an advance directive that says what they want to happen with end of life, whether it's organ donation, whether it's cremation, and then of course end of life procedures, okay? All those dovetail together. They need to be done appropriately and then checked on periodically to make sure that everything's still in place. So that is the end.